Good afternoon, everyone, and welcome to our first virtual EMP Twilight seminar, which is neither at twilight nor involves drinks unless you bring your own. My name is Kathryn Pacey. I'm a partner in the Environment and Planning team here in Brisbane, and I'm joined today by Trainor, who is another one of our partners here. So this being our first EMP webinar, we have a few new rules. One is that we have a Q&A function that you can access in the bottom right-hand corner of your screen. We encourage you to utilise that function and send us questions, and I think some people already have, so thank you very much for that. If we don't get an opportunity to answer your questions, or if you think of additional questions later, as always, please feel free to email us, and we will send out the slides and recording after this event with some of those answers as well. Before I commence, I acknowledge the traditional owners and custodians of the land on which I guess we are all sitting on, and pay respects to the elders past, present and emerging. So to get started, today we are talking about the Interim Statutory Review Report that has been released by Professor Graeme Samuel into the operation of the Environment Protection and Biodiversity Conservation Act. The interim report was released on the 20th of July, so it's pretty brand new. And we will be looking today at some of the key recommendations for reform recommended in that report. Before we get started on the review, a very quick overview of what the Epbc Act actually does. For most people who are not the Commonwealth or on Commonwealth land, the Act regulates actions that have, will have, or are likely to have a significant impact on matters of national environmental significance. And those matters largely reflect international agreements to which Australia is a party, so covers things such as listed threatened species and communities, world heritage, the Great Barrier Reef and migratory species. The Epbc Act also deals with environmental impacts by Commonwealth agencies, international trade of wildlife and the environment on Commonwealth land. So the interim report, which has just been released, what it is that it is the 10-year statutory independent review of the Epbc Act, which is required by Section 522 capital A, which the very numbering of that section may indicate some of the issues with the Act. This is the second independent review that has been undertaken of the Act, the first being the review in 2008, which was done by Alan Hawke. The review came with terms of reference and they have obviously influenced and informed the interim report that has been released. Those terms of reference include recommendations to modernise the Epbc Act and its operation, given that it has just hit its 20th year. Also making decisions simpler, including by reducing unnecessary regulatory burdens for Australians, business and government, which I think is now called green tape, and streamlining and integrating planning to support ecologically sustainable development. It is important to recognise also what this interim report isn't. So it is not a statement of government policy, it is the reviewer's recommendations. It is an interim report, so the final report is to be released at the end of October, and recommendations on the report will be subject to a government response, and there has already been a partial indication from government in response to some of the recommendations. So one of the things that the report did do was look at the operation and effectiveness of the Epbc Act. Perhaps not surprisingly, the review concluded that the environment is in an overall state of decline, is under increasing threat, and that our current environmental trajectory is unsustainable. It also finds that the EPBC Act is ineffective and it does not enable the Commonwealth to play its statutory role. Not surprisingly, therefore, the report has recommended fundamental reform to the EPBC Act. So the key recommendations of the report are underpinned by a focus on protecting the environment in the national interest by way of outcomes rather than by the current focus on transactional elements. So a more landscape outcomes focused approach rather than a project by project approach. Probably the key recommendation for the report is the introduction of legally enforceable national environmental standards. And those standards will underpin a number of the other recommendations put forward by Professor Samuel. There are also recommendations around devolution to the states. So the old one-stop shop has now turned into the perhaps slightly creepily named single touch approvals. There is an intended focus on restoration and rehabilitation of the environment rather than managed decline. Increased Indigenous involvement in decision making, and there is also a recommendation around reform of cultural heritage protections. The report does not recommend any wholesale changes to the matters of national environmental significance, but Kathryn will talk about some of the tweaks that are being recommended. An important recommendation is around improved access to better data, more transparent data, and a single point of truth. The report also recommended strengthening of compliance, enforcement and insurance, which has been the subject of a number of media reports, and also looking at the legal review of decisions, including the extended standing provisions that currently exist in the Act, and the possibility of extension to merits review, which was the subject of a number of submissions. So the national environmental standards, as I said, are fundamental to many of the reforms that have been put forward. Professor Samuel found that fundamental reform of national environmental law is required, and the national environmental standards should be the foundation of that reform. So what are the national environmental standards? They are recommended to be regulatory instruments and legally enforceable, which means that if the standards are to be applied as recommended by Professor Samuel, then legislative amendment to the Act will be required. He also recommends that these standards are granular and measurable, that they are concise, precise, quantitative and outcome-oriented. They provide flexibility for development. They ensure that decisions under the EPBC Act track towards ecologically sustainable development. And importantly, that the standards are required to be applied unless the decision maker can demonstrate that the public interest and the national interest is best served otherwise. So the simple answer is that we don't yet really know exactly what the national environmental standards are. There seems to be a fairly intensive program of work underway in the next 2 months to develop the national environmental standards before the final report is released. We know that the recommendation is that the standards will be made by the Commonwealth through a formal process under the Act, which includes consultation with the states, Indigenous stakeholders and other stakeholders. Professor Samuel has provided prototype standards in the report, which are intended to stimulate discussion through the survey process that's currently underway. Those standards, those prototype standards include an overarching matters of national environmental significance standard and matter-specific standards that deal with the various matters of national environmental significance. For those of you in the mining and CSG industry, you'll probably note there is no standard there for the water trigger. That's on the basis that the trigger cannot currently be devolved to the states. Professor Samuel recommends that if that restriction is removed, then of course a standard will be required for the water trigger. Because the report really presents concepts and is not the detailed map of reform, there are a number of questions that will need to be resolved by government if these national environmental standards are to be introduced. The first is that Professor Samuel has recommended that interim standards be introduced until you get the data to underpin the granular, detailed standards that are intended to be the end product. It's not clear at the moment what role those interim standards are to play, whether they are intended to underpin future devolution to the states. The interim standards are described as a first step to facilitate rapid reform and streamlining and be based on existing data. If the interim standards do underpin devolution to the states and devolution is done on the basis of those standards, there will also need to be some thought given to how you move from the interim standards to the more evolved standards as they are developed and how that's implemented through future decisions and decision-making systems. Second question I think we need to answer is whether the national standards apply to individual project-by-project decisions or whether they apply to systems, so whether they are intended to apply to state and territory environmental assessment systems and legislation in their accreditation or both, and whether there need to be different standards depending on the level at which they apply. It will also need to be clarified whether the standards are intended to apply to all decision makers under the Act, so both the Commonwealth, the state and potentially other decision makers, and whether they apply to those decision makers in the same way. One of the really fundamental questions around that is how much discretion is intended to be in the application of the standards. So Professor Samuel has already indicated that the standards must be complied with unless it is in the public interest or the national interest is best served otherwise. But within the actual standards themselves, I think it will be important to find out how much discretion is afforded to decision makers, particularly if the standards are to be applied on a project-by-project basis. Government has flagged that legislative amendments will be introduced in late August to facilitate the introduction of the standards, so a number of these questions will likely be resolved as part of the preparation of that legislation. As I've mentioned, the report, as underpinned by the standards, has a real focus on devolution. The devolution of decision-making to the states to allow the Commonwealth to focus on the higher order national matters. So the devolution is to be a transparent accreditation of state and territory arrangements and underpinned by a strong assurance framework. So the Commonwealth focus will move to producing the standards and ensuring that assurance framework rather than being involved on a project-by-project basis. For those of you who recall the great days of 2013 to 2015, you might think that this sounds similar to the one-stop shop where legislative amendments were introduced to amend the Epbc Act to try and give effect to the approvals bilaterals that are already provided for in the Epbc Act but required some tweaking. And those legislative amendments to the Epbc Act failed. So each of the states and territories had a draft approvals bilateral with the Commonwealth that are all still sitting on the website, waiting to be revived. At that time, there was a lot of concern from detractors of what was then the one-stop shop that the Commonwealth standards could not be maintained. And at the time, the then Prime Minister Gillard described the process as, I think this is beautiful, the regulatory equivalent of a Dalmatian dog. So hopefully second time round we'll do better. Professor Samuel has recognised that amendments will be required to the Epbc Act to facilitate the devolution to the states, and that includes enabling the Commonwealth to complete an assessment if the state or territory is unable to, and also to ensure that the approvals bilaterals can cope with amendments to state legislation without having to repeat the entire accreditation process, which results in a disallowable instrument being laid before the Commonwealth Parliament. So this is just a map of the proposed devolution model. So moving through from the National Environmental Standards to an accreditation process where the states and territories demonstrate that their systems comply with the national standards. Then the transparent assurance framework, so the Commonwealth can step in where required, followed by a process of regular review and adaptive management. So it's not intended to be a set and forget kind of process. So it sounds like a great idea, and it's certainly receiving a lot of positive press to have the single approval issued by the state that covers the Epbc, but we're lawyers and so therefore we're sceptical and need to see the details. So whether or not it ends up working and whether it works well, I think depends on the national environmental standards and what they end up being, and also the future legislative amendments to help accommodate the devolution. It's already been flagged in the interim report that the Commonwealth should retain a decision-making role in certain circumstances, and that includes obviously where accredited arrangements are not in place, where the jurisdiction requests it, national interest grounds and activities on Commonwealth land, all that involve Commonwealth agencies. So the Commonwealth would, even under a complete devolution model, still have to retain some assessment and approval process within the Epbc Act. Some things to look out for while we wildly embrace a single approval is whether the devolved decision maker has the same discretion as the Commonwealth Minister, and that's going back to that point I made earlier about the level of discretion provided for in the standards, but also what form the final legislation takes. What states and territories need to do to have their decision-making processes accredited. So it's likely that as part of the process, states and territories that are seeking accreditation will need to review their legislation and ensure that it complies with the national environmental standards. That may in itself require legislation to be amended by the states or territories before accreditation can take place. Whether the accreditation process can endure the state or territory amending their laws and what level of amendment is provided for before you're going back through a whole accreditation process again. One thing I think we need to be a bit careful of is what impact amendments to state laws to get accreditation mean for other state approval processes, particularly approval processes that would not otherwise have triggered the Epbc Act. So some care will need to be taken to ensure that what are currently fairly simple state approvals can continue to be assessed as they are. Responsibility for monitoring, compliance and enforcement, I expect would rest with the states and territories, because it will be their conditions and their approvals that compliance and enforcement is required for, although the interaction with the Commonwealth in that space will be important to understand, and that may partly be addressed by whatever the Commonwealth assurance process is. Exclusions on the devolution will be important. Minister Ley has already flagged that exclusions around state approvals to state projects would not form part of the devolved model. And also the resourcing data and assistance that would be provided to the states and territories, recognising that the states and territories are taking on what is currently a fairly intensive Commonwealth role. One of the other sets of recommendations included in the report is around adaptive planning documents, and this is really playing into Professor Samuel's recommendations around the Act taking a more strategic and outcomes-focused approach. So there are two categories of plans that have been recommended. One is strategic national plans, which are to deal with national issues, such as how you deal with feral animals, adaptation to climate change, habitat management, those sorts of things. There are likely to be efficiencies with a national consistent approach on those sorts of matters that are properly the subject of strategic national plans. And logically, there is a link between these plans and environmental offsets under the Act, or whatever they will become, but Kathryn will talk about them shortly. Regional plans are also recommended, so regional recovery plans to be developed by the Commonwealth for the matters of national environmental significance. Bioregional plans developed collaboratively with the states and territories, and strategic assessments, which of course already exist. Professor Samuel has recommended some amendments to strategic assessments. For those of you who've been involved in strategic assessments or have followed them, you'll know that they have proved probably a little more complex, time and resource intensive, and inflexible than was originally contemplated. So amendments that have been proposed to better enable strategic assessments are around addressing the inability to vary a program once it has become endorsed, and the reliance on a statutory regime, either or primarily the state statutory regime, which can be flawed if subsequent amendments are made to that regime. Professor Samuel also recommends that legislative amendments be made to deal with the unclear consequences of a failure to implement a commitment under a strategic assessment, and the legislative links between strategic assessments and the general assessment and approval provisions under the Epbc Act, where there seems to be some discord between the two sets of provisions. So, for example, variations to conditions under strategic assessments don't really work and need some mechanical fixes. So all of those adaptive planning documents are intended to be consistent, again, with the national environmental standards, although the role of those documents through approvals and assessment processes is not entirely clear in the report. I'm now going to hand over to Kathryn.
Good afternoon, everyone. So I'm going to continue with our overview of some of the recommendations and then flag where to from here. And Kathryn mentioned that the reform to offsets regime. And the recommendation is really to overhaul the offset system in view of declining biodiversity. The report has some staggering figures, with Australia having one of the highest extinction rates in the world. More than 10% of land mammals and 21% of threatened species, flagged in the report. the threatened status of species is not improving. So in terms of impacts on biodiversity and the whole process for offsets to mitigate the impacts that can't be avoided needs an overhaul based on the recommendations. And in particular, Professor Samuels looked at the current process in offsets and has some particular concerns about the current process. The Epbc offsets policy was implemented in 2012, and so the policy enables projects to compensate for unavoidable environmental impacts, mostly by protecting areas of habitat that are similar to the area that may be destroyed or damaged by the project. So the offsets policy was underpinned by a notion that as offset availability declines, there will be a greater focus on avoidance and mitigation, but rather that's just led to a concern from industry that the scarcity of offsets means that the offset requirement creates an unworkable impediment to doing business. And while the offset policy has avoid, mitigate and offset as a hierarchy, as a stated intent, that's not necessarily how it has been applied across the board, with offsets being the default option in a number of cases. And also proponents are utilising offsets that don't necessarily ensure there's no net loss, because often the offset area that is chosen is not necessarily an area that would have been exposed to development. So Professor Samuel expresses some concern about the additionality of offsets and the effectiveness of the offset regime in ensuring no net loss. The focus is really in the recommendations of the report on restoration, not decline, and the report makes a number of recommendations to actually achieve that. So the first one is to move from a policy framework, an offsets policy, to a legislative framework where the framework for offsets is mandated in legislation. To move away from what he sees as failings of the current system, where the hierarchy is not necessarily applied in a strict way and results in an overall net loss, to a situation where the new laws will ensure that before an offset is chosen and utilised as the mechanism to mitigate impacts, that the proponent demonstrably exhausts all options to avoid the impacts in the first place. The new laws should be introduced to ensure that offsets are focused on restoration of habitat rather than just replacement of habitat. And given that there are difficulties in ensuring that available land is accessible for offsets, and given that the advanced offsets regime hasn't been utilised very effectively because of uncertainty over whether or not advanced offsets will actually achieve the offset requirement or be accepted by the Commonwealth, the recommendation is for an offset market to be developed, something similar to the carbon market regime, where third-party providers can acquire and create restored offset habitats, which can then be available through a market mechanism to be relied on as part of an offset. And this presumably will allow offsets to be developed in areas where there is a significant focus developed through the regional plans to improve areas such as biodiversity corridors, areas that need significant restoration, and ensuring that there is a move from this overall net loss of offset area to a restoration focus and an improvement in our biodiversity generally. One of the most significant recommendations, I think, in this review is the Indigenous engagement recommendation. So the report, and Professor Samuel makes a comment that the Epbc Act has failed to fulfil its objectives as relates to the role of Indigenous Australians, particularly traditional knowledge in conservation of biodiversity. Indigenous Australians are actually seeking and are entitled to expect a stronger national level protection of their cultural heritage as well, and there's some concerns about the adequacy of legislation to protect Indigenous cultural heritage. And Professor Samuel has recommended that there be some consideration to whether the Epbc Act has a role here. The report does point out that there are a number of international obligations which support a stronger role for Indigenous peoples in Epbc Act decision making. The UN Declaration on Rights of Indigenous Peoples affirms the right of Indigenous people to participate in decision making for matters that affect them. The Convention on Biodiversity recognises that Indigenous peoples have inherent ecological knowledge and require signatories to respect, preserve and maintain such ecological knowledge. And there will also have been a number of targets developed under the Convention to agree to include specific targets for traditional knowledge and practices of Indigenous peoples to be integrated into biodiversity conservation. So in view of those significant international responsibilities, Professor Samuel has recommended a greater role and a more effective role for Indigenous engagement and has recommended the development of a specific national environmental standard to establish what is best practice Indigenous engagement under the Epbc Act. He's also recommended that the role of the Indigenous Advisory Committee needs to be revamped and also that committee would assist with developing that standard on engagement. He's actively encouraging that the reforms be co-designed with Indigenous Australians as well. As Kathryn mentioned, the report does not recommend any wholesale changes to matters of national environmental significance. And this issue in the reform has perhaps been most anticipated with certainly many submissions about whether or not there should be a greenhouse gas trigger, whether or not the water trigger should stay or not. And so Professor Samuel in the interim report suggests that there's no need for any new matters of national environmental significance because that will just confuse and result in duplication of responsibilities between agencies, states, territories and Commonwealth. And particularly in relation to the greenhouse gas trigger, has recommended that there's no need to duplicate the existing Commonwealth framework for regulating emissions, but certainly recommended that there was merit in mandating that proposals be assessed having regard to disclosing full emissions profile. And secondly, that proposals consider the impacts of their projects under a range of climate change scenarios. So there's recommendations for how climate change matters could be addressed as part of the existing framework, but no new greenhouse trigger. The water trigger is to stay but be somewhat limited to consideration of matters that risk irreversible depletion or contamination of cross-border water resources such as the Great Artesian Basin. As Kathryn mentioned, currently the water trigger cannot be devolved under the current arrangements to states and territories. So this recommendation would require the Commonwealth to agree to a legislative modification of the water trigger. And then the Commonwealth, once that had occurred, would be able to develop a national standard to accredit states and territories in management of the impact on water resources. There was certainly also no appetite in the review report to expand the water trigger beyond mining and petroleum. Perhaps one of the most challenging issues for the Epbc Act that Professor Samuel has identified is the difficulties in creating an efficient database of information. There's no single national database or single national source of truth for data, which leads to efficiencies in administering the legislation and also poor decision making at the end where data is absent or not sufficient for the purposes. The collection of data has been pointed out as fragmented, disparate, generally on a project-by-project basis. The systems that are available for information sharing are antiquated. Large amounts of data are not even shared between departments, let alone between governments, and proponents' use of data is not able to be used or shared amongst projects. It's often proprietary data. So there are some significant challenges in terms of availability of data. And Professor Samuel has recognised those challenges, and I think this has been a topic that has been recognised for quite some time as an issue for, you know, a proper administration of a national environmental law. So in the days that we have now of big data, Professor Samuel has, I think, jumped to the challenge and said there should be an easily accessible single source of truth, the ultimate database where governments and proponents and the public can rely on to understand, you know, what are the significant environmental resources that we have here in Australia, what are the likely impacts going to be having regard to a single database of information. Basically, Professor Samuel is again recognising that this is a big task, an expensive task, but a national environmental standard should set some clear requirements for the provision of data and information in a way that fosters transparency and data sharing. Now, certainly that is going to be a significant task for the Commonwealth. It will require significant resources to develop and maintain a single database. There will need to be a quantum shift in the information required, how that information is accessible, and in data storage. And now I'm not no expert in big data, so for those of you who are in that industry, this is a challenge for you, an opportunity to rise to the challenge. There'll be a range of licensing issues, particularly if we are to move from a project-by-project collation of data for assessment to issues to be dealt with about data quality, data integrity, data compatibility. All of those issues will need to be considered. And while there are some examples of where data sharing has been utilised, and one of those is the cumulative management area modelling that OGIA has in Queensland for modelling the impacts of groundwater on and monitoring the impacts of groundwater on specific areas that are sensitive. And that is a very useful precedent of how data sharing can actually achieve some better cumulative assessment of impacts. But the report acknowledges that ultimately having an accessible database will be a significant task, a significant cost associated with it, but ultimately there will be efficiencies in delivery of informed decision making under the Epbc Act, and efficiencies for proponents in having data accessible if this could be achieved. I think this needs to be managed in a stepwise process. Certainly perhaps the implementers of some of the recommendations can look at the landscape focused outcomes that Kathryn mentioned before, to see whether, on a particular landscape or in a particular region, can there be collation of data in a way that can be effectively shared and available, and do this as a stepwise change rather than start out with a grand scheme for one big database that never gets off the ground. But we are in the hands of the big data experts here to see what are the opportunities that we can draw on having regard to the technology that is available today. There will certainly need to be some critical scientific focus on compatibility of data, and also the quality of data that goes into any form of cumulative database that is able to be developed. But certainly something that has been talked about for a long time and would be a great opportunity to achieve better answers under the Epbc Act. Another of the recommendations that Professor Samuel has arises in respect of the compliance, enforcement and assurance area, because of a concern that there has been inadequate compliance and enforcement under the Epbc Act. And Professor Samuel has recommended that there be an independent compliance and enforcement regulator established. And now this is not supported by the current government. The Commonwealth has indicated that it will certainly take steps to strengthen compliance functions and ensure that all bilateral agreements with states and territories have a rigorous assurance regime. It won't, however, support an additional layer of bureaucracy such as the establishment of an independent regulator. So that recommendation looks like it will be considered by government, but an independent regulator does not seem to be likely as on the cards. Another area of recommendation and consideration of Professor Samuel is the legal review process under the Epbc Act. And this was quite contentious as part of the submissions that came in for Professor Samuel to consider. There were certainly submissions criticising procedural challenges and politically motivated challenges or lawfare, or concern that challenges did not necessarily improve decision making. But on the other hand, there was certainly a focus on, from some quarters, that merits reviews should be introduced rather than focusing currently, as is the case, on judicial review, which is very much consideration of procedural matters of decision making rather than the outcome of the decision making. Now, the recommendation here was that there could be introduced limited merits review opportunities on the papers, which would allow for investigation into the outcome of a decision, but without the expense of additional evidence being produced. Now, how effective that limited merits review will be, and whether or not that will meet the appetite of those who are pushing for broader merits review opportunities remains to be seen. He's also recommended a greater transparency of decision making, and the reason is that there's certainly been submissions that legal proceedings were encouraged because they needed to discover information about how the decision was made. And Professor Samuel has indicated that all of the material concerning the decision making should be available publicly, and I actually think that's probably a good idea. In terms of whether or not there should be an extended standing. Currently under the Epbc Act, there is availability for third parties who either have particular expertise in environment or have organisations that have environmental protection as one of the objectives of the organisation, can bring proceedings under the Epbc Act. They don't have to have a direct interest in the outcome of the proceeding. Now, there was certainly a push in the submissions for extended standing to be wound back, but Professor Samuel has formed a view that extended standing should not be curtailed. So where to from here? 3 phases of reform. Phase 1, let's fix in a short term what are the administrative issues that we can fix quickly, and let's develop some interim standards. So Professor Samuel has recommended that there be some short-term immediate fixes, and that will be good to see. Phase 2, initiate some of the more significant reforms, including the reporting and monitoring of Epbc Act performance improvement. And phase 3, a complete overhaul of the legislation to implement the reform system with the national environmental standards operating as part of that reform. So Professor Samuel is recognising that you can't bite off all of the reforms immediately, and a stage process will allow ultimate improvement in Epbc decision making. So what's next? Consultation on the interim report is open until 9 a.m, the 17th of August. And the Minister has already indicated that legislative amendments to be introduced in August 2020 to legislate for the interim national environmental standards and support that devolution to the states and territories, with a final report to be provided by 31 October 2020. So we can now move to questions.
We can move to questions, and thank you to those of you who have submitted questions, which is partly where you miss everybody sitting in the room. So the first question we have is, can you please expand upon what is meant by devolution to the states? I can speculate rather than expand upon that it is primarily, I think, directed at assessment and approvals being given by the states as a single approval. There does not seem to be any explicit intention for it to be more than that, although that is quite a lot. Although I think the wording of the interim report is quite careful not to close the door to that being restricted to effectively approvals being given by the states. Second question we have is, does the review cover the environmental offsets policy and framework? I think that probably came in before your commentary.
I hope so. Happy to take any other questions on that.
These are all for you now. This is good. The Commonwealth has endorsed the New South Wales offset scheme and biodiversity credits. Do you see that system being adopted more widely by the Commonwealth?
Look, I don't think that's the recommendation out of this report. This report is actually saying we need a reform of the offset system, and even though the New South Wales system has some elements of the reform suggested here, I think that one of the significant matters that this reform, if it is introduced, will achieve is that focus on restoration of the environment. And I think that's going well beyond what any of us have considered to date. It's probably quite challenging and in some ways a little bit scary if you have projects out there, but it also will end up with a better environmental outcome, particularly for our declining biodiversity.
And hopefully with the national standards being developed, you'll actually end up with a system of programmed and planned implementation of offsets that are actually directed at achieving the more significant outcomes as well, instead of patchy bit by bit offsets. The next question I certainly can't answer on the basis that I've just had to pay someone to fix my garden, which I ruined, which is how would one restore habitat in an area which has been impacted? I suspect it will have to be at the site of impact or as close as possible, possibly weed management and additional diversity plantings with the adjoining environment. I think, again, that's partly addressed by whatever the national environmental standards as well as the plans end up being, and how that interacts with the offsets network.
Probably the only other thing I'd want to say about that, I mean, there's a lot of clever people out there, and if we do establish an effective offsets market, that should encourage a whole industry of people looking at ways of restoring the environment to create value that they can sell. So I think if it was a credible market, that would encourage some innovative ideas, I imagine.
And quite clever, where most proponents are not in the business of providing and managing offsets. It's not their day-to-day business.
That's true.
This one's definitely for you, Kathryn. What mechanisms will be used by government to obtain data, and has government indicated that it will pay for this data? I think the answer to question 2 is no.
To obtain data, they're looking at developing again a national environmental standard to work out how to do this. So that is, watch this space. In respect of payment, there is a suggestion in the report that ultimately getting big data together and having some single source of truth will create efficiencies in the system, and that's probably right. And it's suggested that perhaps those efficiencies which will benefit proponents should be paid for by proponents. Not sure what that means, but I don't think that government is looking necessarily, or he's not recommending that government necessarily spend money, but he recognises that there will be a significant cost to this. So again, I think we've got to look at the innovators, hopefully around the country, who can look at ways and means of actually relying on technology to integrate the data we have. But as I said, it will be a bit of a challenge to ensure that the data is compatible, the data credible, that it was useful data, and to refine the data and keep a database up and running is a huge exercise in itself. So again, watch this space.
And final question. Views and opinions on the future of the Aboriginal and Torres Strait Islander Heritage Protection Act in light of the potential additional protections these reforms will have for Aboriginal and Torres Strait Islander cultural heritage and knowledge.
Well, the report says that legislation has been pretty ineffective because it's last gasp just before the cultural heritage gets interfered with, the minister can intervene. And what Professor Samuel is advocating is that there be a hard look at whether or not the Epbc Act can be utilised in some way for protection of cultural heritage. He's not recommending a new matter of national environmental significance, though. So there is no clarity exactly on how that is to be done. But he does recommend that Indigenous peoples be involved in looking at these reforms and coming up with ideas and suggestions to better protect Indigenous cultural heritage. So I think that there's a window of opportunity again for Indigenous people who are particularly concerned about protection of their cultural heritage to have a bigger say in how this might be better achieved.
It's certainly a very big issue at the moment, but I didn't get the impression that while Professor Samuel recognises that it's a significant issue and needs to be dealt with, that it's necessarily in the Epbc Act as well.
No, that's right.
Mm. Well, thank you everybody for your questions. That's the end of our questions and the end of our presentation. We will be sending you the slides, and I understand a recording of this so you can sit through it all over again. If you have any questions or thoughts or things you want to discuss, please, as ever, feel free to drop us an email, and we'll look forward to hearing from you. Thank you very much.
Thank you.